Thank you, Senator. Senator Cornyn.
Would you raise your hand if you believe that our existing voting laws are rigged to the detriment of African Americans and persons of color? I don't see any hands. I agree with you. I don't know really where to start. I'm not sure what the John Lewis Voting Rights Act is supposed to try to solve. If you don't believe that the current system is rigged against African Americans or persons of color. What it does look like to me is an enormous power grab by the federal government to the detriment of the states like mine, like Texas. I think one of the ways that people get sucked into this argument is this idea that Shelby County versus Holder somehow decimated the Voting Rights Act. We know that's false. In fact, I voted to reauthorize the Voting Rights Act. I believe someone mentioned it was 98 to 0 in 2006. But what we did point out at the time was our Democratic colleagues chose to say that basically this country was still living in the 60s. In other words, the data that applied to the formula of coverage for the pre-clearance requirement was not updated to current events. Because I think, as has been pointed out, now we're seeing persons of color voting at levels equal to or higher than other parts of the voting population. We should be celebrating the success of the Voting Rights Act. It worked, and thank goodness it did. But in another sense, we've been fighting since the inception of this country for what the role of the federal government is. Is it a national government? Is it a federal government with states having their own sovereign rights? And here, the Supreme Court said there is no general right to review and veto state laws before they actually are enacted. That's what pre-clearance provided in Shelby County. And the Supreme Court said there is no right to that unless it's to remedy past discrimination. And what they pointed out is the Voting Rights Act did work. And that now, as I said, the level of voting by minorities was at or higher than that for the general population. I think we should celebrate the success of the Voting Rights Act. But I have to ask you, Mr. Spakowski, and forgive me if I butcher your name, you're probably used to it by now. I know you studied this area for many, many years, as Ms. Reardon has as well. Do you trust the Biden Department of Justice to make these decisions?
No, not at all. I mean, just to give you one example, when Arizona decided, one of the things that I've recommended for years is that all states should put in audit requirements. That's ubiquitous in the business world, and states ought to audit their elections after they're over, make sure that everything was done properly, the equipment all works, that they complied with the law. When Arizona decided to do an audit, the Justice Department suddenly said, oh, you can't do that. That's a violation of the Voting Rights Act. Well, that's ridiculous. Of course it's not a violation of the Voting Rights Act. But Senator, you were saying, what's the purpose of this bill? Can I give you one example of what I think the purpose is? It makes changes to Section 2 that would make it almost impossible for states to defend ordinary, regular practices of voting. And the example I would give you is that, Arizona was sued in a case went all the way to the Supreme Court, the Baranovich decision, in which, why were they sued? Well, because like the vast majority of states, they said, look, you have to vote in the precinct you're assigned to. And if you vote outside of that precinct, we're not going to count your ballot. That's the rule in most states. It's been that way for decades. And yet what the Section 2 change would make is to say, oh, if you or a state are sued under Section 2, you can't defend a law, you can't claim it's not discriminatory by showing that this is a traditional voting rule that's long established and that has been used in the majority of states. That will no longer be a defense.